Welcome everyone and thank you for attending. Questions can be asked using the Q&A pane in your Webex event control panel. Today's presentation is being recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Thank you, Christy. Good afternoon, SHRM, Long Island. Today is July 31st, 2020, one of the more rainy days we've had this summer, at least to my recollection. I am coming to you from a place that I haven't been since February, I think, for these updates. I am actually back in our Long Island office, like I'm sure many of you. There's been a slow return to the office. So it is great to talk to you back from where I feel like shouldn't be, but feels like home sometimes. With that said, hopefully everybody is remaining safe. Today did not, other than it being a dreary day, today did not feel like another day to pound more COVID, travel advisory, reopening, CDC, and all the alphabet soup of other DOH alphabet soup of things out there into your head yet again. Obviously, I understand that many of you probably still have questions. There's still a lot of unknown out there. So to the extent you have questions with whether it be return to work, reopening, social distancing, mask wearing, the list goes on, temperature checks, daily screening, what does the EEOC say? What does OSHA say? What does the ADA say? What does New York State say? What's going on with schools? What's FFCRA going to do? What's the quarantine leave law going to do? It's all stuff that back in February we never even thought twice about, and now it's likely more than 50 to 75% of your daily lives when it at least comes to work. So to the extent you have those questions, please never hesitate to reach out to counsel if you work with us. Hopefully you can contact whichever attorney you work with here, and we would be more than happy to help you out. So today, as I said, I will not bore you with everything that you've probably been inundated with for the last several months. There's been a major change at the labor board, and before you instantly tune me out and say, I don't have a union, I don't have a contract, I don't collectively bargain anything, we're proudly have remained without a union for X amount of years. This is something that matters to you whether you're union or non-union. I don't want you to think that this only applies if you have a union on site, because it doesn't. This is a handbook issue. This is a policy issue. This is a discipline issue. This is a suspension and termination issue. This matters for all employers because it falls under the National Labor Relations Act, which is going to apply to all employers. This is not something that only comes into play when employees vote in a union. So it's going to get a little flashy today. There are no swear words, although that would provide for some Friday afternoon excitement. There are no swear words in any of this material. Everything has been bleeped out to some extent. I will do my best to not slip up and say any of them. I think we will understand exactly what they mean, but we're going to see somewhat of a sea change between what things were and what things now look like they are set to become. So, what's new? This all changed last week, late last week, in a sweeping decision that overruled several board precedent-setting cases. The Labor Board decided that it will no longer apply setting specific standards for determining when an employee's abusive conduct loses the protection of the NLRA. So the case is General Motors, 2020, I think it's July 21st or 22nd it came out. But setting specific, what that meant to us, and we're going to get into this in a little bit in more detail, but leading into this case, the board applied different, depending on where employees' conduct occurred, in the workplace towards management, on social media, on a picket line, depending where the conduct occurred, the board applied different tests. So it was sloppy. It was hard to follow. You had to jump through hoops to figure out whether you could or you could not discipline employees for speech and certain offensive, profane outbursts that they would have, because what we started to see a lot of under a President Obama board just largely because it was a Democratic appointees. Under that board, we saw a lot of employee protection, and employees would not lose protection under the National Labor Relations Act for their speech, which led to employees cursing out employers, which led to employees profane, offensive, hostile outbursts that would then be that an employer would think, of course I'm going to terminate this person. The employee would then file an unfair labor practice with the labor board. Again, does not have to be a union employee or a bargaining unit member. They would file their unfair labor practice, and an administrative law judge, whether they, whatever they did, whether they agreed with the employee or disagreed, it would get up to the labor board on appeal, and the labor board, under President Obama, would routinely say the employee didn't lose the protection of the act. And when I say that, what it means is an employee is allowed to discuss his or her terms and conditions of employment. They are allowed to engage in protected concerted activity. We probably all heard that, the PCA language. When an employee doesn't, if an employer disciplines an employee, and the employee claims, well, you're disciplining me because I engaged in that activity, because I engaged in discussions about overtime, or discussions about scheduling, or about seniority, or about the treatment of this from this supervisor, something relating to the terms and conditions of employment. I think you discipline me for that reason, and you're violating my Section 7 rights, my Section 7 under the NLRA rights. I have the right to discuss my terms and conditions of employment. More often than not, the President Obama Labor Board would say, you know what? You didn't, just because you had an obscene outburst, employee, you didn't lose the protection of the act. You were still, your employer still, whatever they did, suspend, fire, discipline, they did it unlawfully. They cannot do that because you have a Section 7 right to engage in such conduct, to discuss your terms and conditions of employment, basically for the greater good of the workforce. That's the concerted part. It can't just be one person. It's got to be at least two. So going back to this General Motors case, which is going to become more and more important as the months go on and we get back to some sense of normalcy, where there's going to, unfortunately, employers are going to be faced with the problems that they probably miss from prior to January and February of this year. The normal employee curses somebody out in the workplace, employee is abusive in some way, shape, or form. Those issues, although we never liked them when we had them, I'm sure we all yearn for them back, because it will mean that hopefully there's some sense of normalcy in the workplace. So the NLRB modified its standard for determining whether an employee has lost the protection of the NLRA, the Labor Act, and been lawfully disciplined or discharged after making abusive or offensive comments in work-related situations. So the key focus on abusive or offensive comments. We're going to get into in a little bit how there's one area, and it's going to deal with the Facebook, the like button. For any of you that have a Facebook account or even an Instagram account, when you heart something and you like it, you love it, whatever. That under President Obama was found to be protected speech. The Labor Board here, General Motors here, does not overturn that, so that still exists. I would not be shocked if that case does change at some point, if it gets up to the Labor Board, but we're not there yet. So this is really about abusive or offensive comments in work-related situations. Not focusing on an employee disparaging or being disloyal to an employer. This is about an employee being abusive in the workplace with their language. It's a little bit different, a little bit narrower. So the decision will be applied retroactively, so that's just good to note that this is all pending cases is going to be looked at retroactively now. So what happened in this case? This employee on 3 separate occasions was disciplined for using invective towards management personnel while engaging in protected concerted activity protected by Section 7 of the NLRA. So he files his unfair labor practice charge, and filing that charge, and an administrative law judge who can't change the law, can only look at the law the way it is, looks at the law, which is under the President Obama board, and says, yep, you know what, I think the employer was wrong here for your April 11th conduct, and I highlighted that underneath. I think that you didn't lose the protection of the act there, so the employer couldn't have taken action against you. So what did the employer say? What did the employee say that was protected under the administrative law judge's view? The employee, in arguing about overtime coverage, said he did not give a F about your cross-training, that we're not going to do any effing cross-training if you're going to be acting that way, and that the manager could shove it up his effing A. So that's me bleeping myself out, but I think we all know what those, and obviously he said those words. He didn't say them with, little asterisks, but the administrative law judge, I shouldn't even say shockingly because it became the state of the law, somewhat unsurprisingly said, okay, that's, as far as I'm concerned, that's protected. The employer can't take any action against you for that reason. You have a right to engage in that conduct because you're talking about your terms and conditions of employment, and that such a tirade is okay. A little crazy. I don't think anybody likes it, but it's something that we became used to under President Obama board. The employer obviously just appealed the decision to a board that is now covered with a Republican majority. So this was something that was ripe to go to this board. And, regardless of your political views, if you are an employer, a Republican board will generally make things better for you. And we've seen a lot of employer-friendly decisions. So the NLRB reverses the judge. We're going to get into what that test that changed, but just something that I thought I also wanted to put in here because I think it's also relevant for what you're going to be seeing in the next 3 or so months as we approach a very very divisive presidential election. The NLRA just generally protects employees from retaliation for engaging in the PCA, the protected concerted activity. What is it? Typically 2 or more employees that act together. And again, just to stress it, this is not just for union folks. This is for everybody. 2 or more employees acting together to attempt to improve their working conditions, or one person acting on behalf of others. So, I come to you on behalf of all the maintenance workers, on behalf of all the direct care professionals, whatever, on behalf of all the bank tellers, whatever it may be. It includes political speech. This is something that could be protected. Political speech / activity when that activity has a sufficient connection to the workplace or to employees' terms and conditions of employment. Again, it's a very broad, open-ended standard to get Section 7 protection for employees. At least it's been for many years. It will also apply inside and outside the workplace. I think we all know that. It's not just, what's said within the workplace. Political activity unrelated to a specifically identified employment concern is not protected. So, again, if it's not protected, an employer can take action against it. Vote for Smith, so in this case, vote for Biden, vote for Trump, et cetera, vote for some other candidate that I'm not aware of, or discussions regarding capital gains restrictions. So those things, when they're not protected, if it's got nothing to do with an employment issue, those you could take action against. Again, you got to do it intelligently, depending on what you've done in the past, but those you can act against. Political activity for or against a specific issue related to a specifically identified employment concern. So now we're in the employment context. When it has to do with something that is in the workplace, terms and conditions of employment, vote to raise the minimum wage, right to work legislation, and anything about unions, those are the things where it's going to get a little bit trickier if you're going to try to stop them. And I'd strongly recommend you speak with counsel, depending on the situation, if you are trying to, if somebody brings a button or nowadays a face mask that, has questionable messaging on it or political messaging on it, and, we are unfortunately seeing a lot of this, whether it be over candidates, whether it be over social justice movements. If you have questions, if these situations come up, your reaction and your response is going to define more than just that, define the standard for more than just that one employee. In the days of social media, it can spread like wildfire. So just make sure, whatever action you're taking, whether you're going to try to be progressive, conservative, whatever it is, consider discussing with counsel just to make sure that everything is applied appropriately. So the old standard, this is the President Obama board. The board expanded protections for employees who cursed, made inappropriate comments, or threatened their employers while otherwise engaging in PCA. As I said earlier, there's different settings, so picket line, social media, in the workplace, you got different tests. For outbursts to management in the workplace, I just put this here just so you have it, so you could see what it has been up until, I guess, about a week ago. the board had a fourth, and this is the one that came up most often. Is a 70s or 80s case called Atlantic Steel. The board applied a four-factor test examining the place of the discussion, the subject matter of the discussion. This is what it will look at, these four factors, the board, to determine whether or not the employee lost the protection of the act, depending on the conduct. And we could sit here and go over thousands of hypotheticals and have to try to guess what the outcome would be. But we have some examples. Social media then also came into play, obviously, as the 2000s and 2010s started to take off with Twitter and Facebook and things of that nature. The board then developed a nine-factor totality of the circumstances test for social media conduct. So some examples of what was okay under the old standard. During a union organizing drive, an employee posted on Facebook, "Bob is such a nasty mother F. Don't know how to talk to people. F his mother and his entire effing family. What a loser. Vote yes for the union." Shockingly, unshockingly, that was found to be protected speech under the National Labor Relations Act. So the employer was told that they were wrong for disciplining that employee in that situation. And that went up to the Second Circuit, the Court of Appeals that covers New York. And the employee's post, according to the Second Circuit, the employee's post sat at the outer bounds of protected union-related comments. So sat at the outer bounds, not out of bounds, sat at the outer bounds. And it agreed with the board that the employee's conduct was not so egregious as to lose the protection of the NLRA. Scary, shocking for employers. You can see the year 2014. That was a president 2008, 2016. That was a President Obama board. In the middle of a meeting about commissions, minimum wage, and employee breaks. So all employee terms and condition issues. An employee called his supervisor a effing crook, an a-hole, and a effing mother effing. We have that. That was found to be okay, and you have to sometimes just laugh about it because it's scary how far this was pushed, and how much protection was given to employees. After a supervisor warned employees to shorten their breaks, 2 employees responded that things would, quote, get ugly if they were fired, and 1 warned his supervisor to, quote, better bring your boxing gloves. So unless the supervisor was Mike Tyson, then I'm a little scared with that threat. Employee wrote, "Dear," you can read that yourself, "please read," and "Hey, cat food lovers, how's your income doing?" You can all figure out the innuendo on your own. On union newsletters left in the women's bathroom during union organizing drives. That was okay. So, again, it was a far reach that gave, and it put employers in a spot because you would see these things and you would say, wait a second, that's discriminatory based on gender and sex. That's offensive to women, objectively and subjectively offensive. But the board, the NLRA existed and still exists and seemed to sometimes give employers or employees greater protections under that act than they would be entitled to under Title VII and state human rights laws, which was, made a nightmare for employers because how do you discipline and comply with laws that seem to run in conflict of each other? So where are we now? Breath of fresh air for employers. In the GM decision, the board noted that its history of inconsistent standards and decisions raised, quote, serious concerns that the board is giving little, if any, consideration to employers' right to maintain order and respect. So hallelujah, employers get a sigh of relief, and they get a little they get a helping hand for the first time on this issue in a long time. The NLRB concluded the series of tests. Again, we talked about the different settings for different tests. Different tests for different settings. Series of tests has strayed from the precepts of the NLRA, which call for the determination of whether an employee would have been discharged. So the question is, would they have been discharged for the conduct regardless of their actions or expressed sentiments in favor of unions or other protected conduct? Were we getting rid of them? Were we terminating them, disciplining them, suspending them, et cetera, because of their Section 7 activity, or because that's how we treat everybody that does things like that? You would hope it's the latter, that we do it because that's how we treat everybody that says such offensive and abusive things. So the NLRB applies a very famous and important right-line decision that the proper standard for deciding these cases where employees engage in abusive conduct in connection with Section 7 activity and the employer asserts it issued discipline because of the abusive conduct, this is a mixed motive analysis. So the employee is going to say, you disciplined me, you terminated me, you did whatever to me because of my Section 7 activity because of my engaging in my protected concerted activity. That's retaliation. You can't do that. Employer's going to say, no, we did this because you cursed out a supervisor, and anybody that cursed out a supervisor, this is how we treat. So again, it's important that this is something where we see in harassment training, consistency, enforcing our policies consistently across the board, very important. So what's the test now? The general counsel has an initial burden. They must prove that the employee's protected activity was a motivating factor in the discipline. Then the employer must prove that it would have taken the same action, even in the absence of the Section 7 activities. This is what I keep trying to hit home, that we need to be able to show we do this to everybody. It's not just, we're not just doing this to you because of a union issue or because of a Section 7 issue or because you complained about your terms and conditions of employment. We do this to everybody when you use such profane and abusive and offensive language. The NLRB determined that it would apply right line in these cases regardless of the setting. So this mixed setting issue is gone now. So some takeaways. Employers will remain subject to the right line test, under which the employer must demonstrate that an employee engaging in unacceptable behavior would have been terminated or disciplined regardless of their engaging in any Section 7 activity. So I think I've said that 4 times now. For example, if an employer tolerates low-level vulgarity on an ongoing basis in his work environment, and an employee who favors the union utilizes the same low-level vulgarity is discharged, it may be difficult to defend that termination decision since others who have not engaged in protected activity did not suffer a similar consequence. Summary in one word: consistency. Be consistent in the enforcement of your policies and enforce your policies. Before disciplining employees for engaging in abusive conduct, employers should determine whether the employee was involved in protected concerted activity while doing so, and whether the employee would have been disciplined even if they were not engaged in protected concerted activity. So the final slide, I thought this was an important quote to give everybody. For too long, this is the chairman of the NLRB. For too long, the board has protected employees who engage in obscene, racist, and sexually harassing speech not tolerated in almost any workplace today, especially in New York. Our decision in General Motors ends this unwarranted protection, eliminates the conflict between the NLRA and anti-discrimination laws. It acknowledges that the expectations for employee conduct in the workplace have changed. I mentioned before the Facebook like situation. When an employee goes on there and disparages an employer, it is that case law from 2015 still is on the books. This General Motors case has not changed that. This is narrowed on just the focus of discipline for abusive conduct. As we said, this employee in this situation said, shove it up his F&A and told him basically to F himself. That was just abusive conduct. It wasn't about disparaging the employer. It was abusive towards the supervisor. So what should you do? Review and update your policies, your code of conduct. If you have a respectful workplace policy, a social media policy, look into them. You have some more room to discipline now. We probably every couple of years you come to the breakfast series and you hear Chris or Ian or somebody talking to you about this is how you should change your handbook. This is what you should do. If you were there in January, you heard both me and Ian speaking about it. This is what you need to do. Restrict this, restrict this. If you were there in January, you heard Ian and I talking about how you could slowly get a little bit more aggressive with your handbook. This is only furthering that MO. Keep going and have counsel look at your policies, and then make sure your policies are actively enforced in a non-discriminatory fashion. Do it across the board. Don't fall asleep at the wheel. Make sure that we are treating everybody the same and enforcing our written policies. If we don't like our written policies, let's revise them, let's update them, and let's push those out to employees so they know the standards. That being said, I apologize for running a little bit over. Thank you, everybody, for joining. Stay safe. Please be careful out there. I will look forward to speaking to you again at the end of August. Hopefully we are continuing to track forward to a safer, happier world, which will hopefully be a healthier world as we go. So with that said, enjoy your weekend. Have a wonderful rest of your summer, and I look forward to speaking to you right before Labor Day. Take care, everybody.